affirmative action could end at U.S. universities sooner than expected. Jess Bravin, who covers the Supreme Court for the Wall Street Journal, joins us from Washington. Jess, previously the court had said, really, it was a famous line from Sandra Day O'Connor in a 2003 decision that we might need affirmative action for a quarter century. Why are they revisiting that decision now?
Well, there's a technical reason, and then there is a sort of more realistic reason. The technical reason is they decided to accept a case in which the University of Texas affirmative action program is at issue. I'd say the broader reason is that Sandra Day O'Connor is no longer on the Supreme Court, and her successor, Justice Samuel Alito, appointed by President Bush, has shown that he is much more skeptical of racial preferences, even for what are supposed to be benign purposes, than was Justice O'Connor. And since that was a 5-4 decision in 2003, it's possible that we might see a different outcome when a similar issue comes up this year.
So tell us briefly about this UT case and what changes we might expect given the makeup of the court.
Well, of course, we don't know. I mean, the arguments are on October 10th, which is the first during the first sitting of the Supreme Court, which returns from its vacation next week. So we don't know exactly what they're going to do, and perhaps we'll learn a little bit at oral arguments. But basically, the University of Texas currently accepts the top 10% of graduates from every Texas high school, and that has gotten them to a point of being a relatively diverse student body with about 50% white enrollment, about 19% Hispanic enrollment, about 5% Black enrollment. But the university does not want to simply take the top 10% of every high school to attain those goals. What it wants to be able to do is select minority students who are from other schools. Perhaps they're in the top 20% or the top 30% of more competitive schools. So they want to be able to essentially consider race in some cases when assembling their student body. The challenge says that no, it's unconstitutional to classify students by race and to use race as a plus factor in university admissions when it's not absolutely necessary to attain diversity. And Texas has proven it's not necessary to attain diversity because of its, what I said before, the top 10% plan.
Okay, and let's remind people, 5 years ago, the court blocked elementary and secondary schools from considering race in some assignments. And at the time, Chief Justice Roberts, he wrote, quote, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." But also, it's interesting here you have...
There are 4 votes on this court that are quite likely to rule against the University of Texas. And by the way, it's not just the University of Texas, although they are the defendant in this case. Virtually the entire higher education community is behind them, from state universities to the Ivy League, the Obama administration. Half of the Fortune 100 companies are supporting affirmative action. A coalition of retired military generals and admirals is basically there's a huge lineup of, I'd say, the established institutional community in America agreeing with affirmative action. Very few such institutions on the other side challenging it. Yes, the case involving elementary and secondary schools, it was distinguished. The court said then they're only talking about elementary and secondary schools which don't have competitive admissions, which the only criterion for admission is residence. But yes, those 4 votes that joined with the Chief Justice are likely to be quite skeptical of what UT is doing. The mystery in this case is, of course, Justice Anthony Kennedy, who agreed with the outcome in that K-12 case, and yet said that diversity is a compelling state interest. He just didn't believe the way that those public schools were achieving it was permissible. The question that we'll be watching for is whether Justice Kennedy believes that what UT is doing is acceptable, or whether it's just a sort of disguised quota, which is something he says is not acceptable. He wants to see students evaluated as individuals.